All right, Sunday. Federal Judge Aileen Cannon removed from the bench. Done. According to court documents filed Friday, U.S. Marshals entered her chambers Thursday morning, 6:47 a.m., seized 14 boxes of materials, not evidence from a case, not standard case files, documents she was ordered to destroy. Classified materials she was explicitly prohibited from retaining, still there in her private office. $127 million. That's the estimated value of the security breach. 23 witnesses cooperated. The judicial complaint runs 340 pages. I've been going through this all weekend. Every filing, every exhibit. Here's what I found. And honestly, what the mainstream coverage is missing is the part that matters most. Quick context. Judge Aileen Cannon, federal district judge for the Southern District of Florida, appointed 2020, became nationally known for presiding over one of the most high-profile cases in recent history. The issue? According to newly surfaced records, she allegedly retained classified documents, materials she had reviewed in chambers, well past their mandated destruction date. We're talking national security documents, the kind with cover sheets. Timeline, fast version. Months ago, internal whistleblower at the courthouse flagged irregularities in document handling. Weeks later, Judicial Council opened a formal investigation without public announcement. Last week, the dam broke. She was not removed for her rulings, not removed for her judicial philosophy, not removed for being slow with decisions. She was removed for allegedly violating federal document retention law, for allegedly maintaining custody of classified materials in an unsecured office, for allegedly lying to investigators about it. That's the setup. Now the documents. What I'm about to walk you through comes directly from public filings, official complaints, witness statements under oath. Not speculation, not editorial, documents. Okay. The evidence. First document, filed Friday, the formal Judicial Council complaint. I pulled page 47. It says, quoting here, Judge Cannon failed to comply with repeated directives from the Administrative Office of the Courts regarding the destruction of classified materials reviewed in camera. That's not my take, that's the filing. What it means? She was told to destroy sensitive documents multiple times. She didn't do it. But here's what got me. Page 89, different section. The inventory list from the Marshals seizure. 14 boxes, 2,847 individual pages, 12 items marked at the secret level, 3 items marked top secret /SCI. All of it should have been returned to DOJ custody or destroyed by July 2025. It's now March 2026. Put those together, 8 months past the deadline, still sitting in her chambers. I went through this 4 times. Patterns clear. Directive issued June 2025 to return materials. No compliance documented. Follow-up directive, August 2025. No response on file. Whistleblower complaint, September 2025. Investigation opened October 2025. All documented. Now, what nobody's covering. Page 203 of the complaint, Exhibit K. Email chain between Cannon's chambers and a third-party document storage company in Boca Raton, dated November 2025. Her staff requested quotes for long-term secure storage of legal materials. They weren't planning to destroy these documents. According to the filing, they were planning to move them somewhere else. Read that again. That changes this. The complaint alleges this wasn't negligence. It was intentional retention. Fallout. Her security clearance revoked. Her access to the federal courthouse system suspended. Her pending cases, all 34 of them, reassigned to other judges within 72 hours of the seizure. Now, let me walk you through the witness statements. 19 court employees provided testimony, page 156 through 189. One senior clerk, 22 years on the job, said under oath, "I raised concerns in writing twice. Both times I was told to mind my business." Another staffer, a courtroom deputy, "She had her own system for those files. Nobody else touched that cabinet." Here's the one that stands out, page 177, a former law clerk who left in 2025. "I was asked to remove classification markings from certain documents before they were scanned into her personal files. I refused. My clerkship ended early." That allegation is now being investigated separately by the DOJ Inspector General. The financial piece matters too. According to the complaint, the security remediation costs, sweeping her chambers, conducting damage assessments, counterintelligence review, total $127 million so far. That's not a typo. $127 million paid by taxpayers for one judge's alleged document handling. Final piece of evidence, the Judicial Council's own summary, page 12. The conduct alleged, if proven, represents the most serious breach of judicial ethics involving classified materials in the modern history of the federal judiciary. Their words, not mine. That's just the first layer of documents. If this breakdown's useful, subscribe. I'm going to cover this entire story as it develops. What I show you next is the part that makes people uncomfortable. Okay, but look. Got to be fair here. The other side has a point. Few points, actually. Cannon's defenders say this is a political hit job. They say the timing is suspicious. They say she's being targeted for rulings she made, not document handling. And honestly, some of it holds up. Their argument. First, the investigation started right after she made several controversial rulings that angered the Justice Department. That's not conspiracy theory, that's timeline. Second, no criminal charges have been filed. This is administrative. If this were really about classified documents, why isn't DOJ prosecuting? Third, she's a Trump appointee being investigated by a judicial council with a Democratic-appointed majority. The optics matter. Former federal judge and conservative commentator William Paulson put it this way: "This has the fingerprints of institutional retaliation all over it." Don't agree with all of it, but that's not nothing. What they've got. The Judicial Council has never removed a judge this quickly before. The Inspector General investigation is still ongoing, no conclusions yet. Several House Republicans are calling this unprecedented overreach. Her legal team released a statement Thursday night. Judge Cannon maintained these materials pursuant to what she believed was proper legal authority. She will contest this action vigorously. That's a defense. Whether it's a good one, that's a different question. Even retired federal judge Maria Contreras, no conservative, admits the speed of this removal is unusual. Due process concerns are legitimate. When judges across the spectrum agree something's unusual, pay attention. Look, I'm not here to tell you who's right. The "she was targeted" interpretation, there's evidence pointing that direction. The timing, the speed, the political dynamics. The "she broke the law" interpretation, there's evidence there too. The documents, the witness statements, the retention past deadline. Both can be true. That's what makes this complicated. You can believe she was treated unfairly and believe she shouldn't have kept those documents. This isn't sports. You don't have to pick a team. What I can tell you, what the documents show. And they show 14 boxes of classified materials in her chambers 8 months after destruction was ordered. They show 19 witnesses saying she ran a separate system for those files. They show $127 million in security costs. That's not spin, that's the filing. What you make of it is your call. But here's what bothers me about the, quote, political hit job defense. Even if the investigation was politically motivated, and that's a real if, the documents were still there. The materials were still retained. The directives were still ignored. Motivation for looking doesn't change what they found. and they found classified documents where classified documents shouldn't have been. That's the bridge to the next part, because this didn't start last week. This didn't come out of nowhere. Backstory, quick. Over a year ago, internal courthouse IT flagged unusual scanning activity from Cannon's chambers, large volumes, after hours. Months later, administrative office noticed she hadn't filed required certifications for classified material handling. Other judges in the district had. Then, the whistleblower, a court security officer who noticed Cannon's clerk accessing storage areas without proper authorization. Someone even said, on record, "I reported it up the chain. Took 6 months before anyone did anything." What happened? Politics. What always happens. Nobody wanted to investigate a sitting federal judge, especially one with that profile, especially in that political climate. Pattern. Red flags ignored. Complaints slow-walked. Investigation delayed until it couldn't be anymore. Every time, got away with it. Until Thursday. What changed? The scale became impossible to ignore. According to the complaint, when the Marshals finally executed the seizure order, they expected to find maybe a box or two of overlooked materials. Standard stuff, happens sometimes. They found 14 boxes, nearly 3,000 pages, multiple classification levels. One senior court administrator told investigators, "I've never seen anything like it, not in 30 years. The investigation that was supposed to be a quiet internal review became the biggest judicial ethics case in decades. Not because someone wanted headlines, because the evidence was too significant to handle any other way." See where this is going? If this is making sense so far, like this video. What I'm about to show you is the actual seizure, what happened Thursday morning, and what came out of those boxes. Thursday, 6:47 a.m. Here's what happened. U.S. Marshals arrived at the federal courthouse in Fort Pierce with a sealed order from the chief judge of the 11th Circuit. No advance notice to Cannon, no coordination with her chambers. They entered her office suite while she was en route from her home, hadn't even arrived yet. The seizure was conducted pursuant to judicial order and completed within 4 hours. That's from the Marshals' official statement. Cannon arrived at 8:15, found her office cordoned off with evidence tape. What followed? She was escorted to the chief judge's chambers, informed of the Judicial Council's decision, handed formal removal paperwork, asked to surrender her credentials. 47 minutes. That fast. Now, what everyone missed. While media focused on the dramatic images, the evidence tape, the boxes being wheeled out, something else happened. A separate team of FBI agents executed a search warrant at a storage facility in Palm Beach County. Then a second search at a private residence connected to one of her former clerks. The DOJ's response? No comment on ongoing investigation. Wasn't reactive, calculated. You can see it in the coordination. Multiple locations, same morning, different agencies. This wasn't about one judge keeping some files too long. According to sources cited in the judicial complaint, investigators believe materials may have been copied, shared, distributed outside proper channels. That's still alleged, not proven, but it explains the $127 million security review. It explains the scope. It explains why DOJ won't comment. This is where it gets interesting. Because if it was just about Cannon keeping documents she shouldn't have, that's bad. Career-ending, probably criminal. But if documents were copied and distributed, that's a national security incident. And the investigation isn't close to over. Don't go anywhere. What I show next is what legal experts are saying this means, not just for Cannon, but for anyone who's ever had a case in her courtroom. Drop your prediction below, then keep watching. What are the experts saying? Former Deputy Attorney General under 2 administrations, 28 years in federal law enforcement. If a federal judge deliberately retained classified materials past destruction dates, that's a federal crime. Full stop. Plain English, what she allegedly did isn't a technicality. It's potentially prosecutable. Another one, constitutional law professor at Georgetown, specializes in judicial ethics. Removal from the bench is just the administrative consequence. The criminal exposure here is substantial. Key there, this isn't over when she loses her judgeship. It's potentially just starting. Here's what's interesting. Even Jonathan Turley, who's defended judges against overreach before, admits the facts alleged in this complaint are difficult to explain away. If accurate, this represents a serious breach of judicial duty. When both sides agree the facts are bad, pay attention. Former assistant U.S. attorney, now in private practice. I've prosecuted document retention cases. The elements here, if proven, check every box. Federal criminal defense attorney who's represented clients in national security cases. She needs excellent lawyers, plural. This is multi-track exposure, administrative, civil, and criminal, all at once. Consensus from people who actually practice this law. The administrative removal was legally justified based on what's public. Criminal referral to DOJ is almost certain. Her pending cases will face years of appeals based on her conduct. That's where the professionals land. One more, former federal magistrate judge, now retired. Every defendant she sentenced, every motion she ruled on, every case she touched, all of it just became potentially appealable. That's thousands of proceedings. Think about that. This isn't just about one judge. It's about every case she ever handled. Every person still in prison based on her rulings. Every civil dispute she decided. The ripple effects here haven't even begun. Useful breakdown so far? Hit like. Seriously, it matters more than you'd think for getting this in front of more people. What comes next is the part most people don't want to hear. Why should you care? Real talk, how this affects actual people. Your tax money. If you pay federal taxes, pay attention. $127 million. That's the security review cost so far. Not the total. So far. According to budget analysts, complete remediation could exceed $300 million when you factor in counterintelligence assessments, document tracking, and potential compromise mitigation. Your wallet. That's money not going to other things. Courts, infrastructure, services. What some agencies are already doing, redirecting discretionary funds to cover security costs. Not advice, just what the budget documents show. Precedent. This sets a precedent, a big one. Next time you hear about judicial accountability or lack of it, remember this case. Quick example. Say you're ever in federal court. Traffic stop turned into federal charges. Business dispute that escalated. Whatever. Your judge's conduct now has a different framework. The Cannon removal proves judges can be held accountable for misconduct. The system worked, eventually. Or did it? Because it took over a year for anyone to act on the first complaint. Over a year of her continuing to hear cases, issue rulings, sentence defendants. Not dramatic, that's how the system worked here. Who's affected? Right now, every person with a case she touched. According to court records, Cannon handled 847 cases during her time on the bench. Criminal defendants, civil litigants, immigration matters. Defense attorneys are already filing motions. 23 appeals were submitted within 48 hours of the removal announcement. People in federal prison based on her sentences, their lawyers are mobilizing. Hits immediately. What nobody wants to say. Uncomfortable part. If a federal judge can retain classified documents for months, ignore destruction orders, and only face consequences when it becomes politically impossible to ignore, what does that say about accountability? If you ever believed federal judges were somehow above this, they're not. Not trying to scare you. That's what the record suggests. Practical, what informed people are doing. If you have a case in Southern District of Florida, check if Cannon was involved. If you were sentenced or ruled against by her, consult an attorney about appeal options. If you're following judicial appointments, this case is now the reference point. Questions to ask a legal professional. Does this removal affect any matter I was involved in? What are the grounds for appeal based on judge misconduct? How long do I have to act? Knowledge helps. This isn't about partisan politics, Republican or Democrat. If you were in her courtroom, you're potentially affected. 847 cases. That's a lot of people who need answers right now. How'd Cannon respond? Made it worse. Honestly. Thursday afternoon, hours after the removal, her attorney released a statement calling the action unconstitutional and politically motivated persecution. Quote, Judge Cannon intends to fight this injustice through every legal avenue available. Reaction? Legal experts immediately pointed out removal was conducted by fellow judges, not politicians. Her own professional association declined to comment in her defense. The Judicial Council came back. The action taken was based solely on documented conduct, not judicial philosophy or political considerations. Then Friday happened. Her legal team filed an emergency motion to stay the removal. Denied within hours. They filed an appeal to the Supreme Court. No response yet. Meanwhile, 3 of her former law clerks released a joint statement. We are shocked and saddened. Judge Cannon was demanding, but always ethical in our experience. That helped her public image somewhat. But then a 4th former clerk, the one who said she asked him to remove classification markings, gave an interview. I stayed quiet for months. I can't anymore. Not cooling down, heating up. Her defenders are organizing. House Republicans have announced oversight hearings. Cable news is divided along predictable lines. But the documents are public. The witness statements are under oath. Whatever her defenders say, they have to contend with 340 pages of documented allegations. That's not going away. What's still unclear? 1. Were documents actually copied and distributed? The complaint hints at this, but doesn't confirm. The FBI searches suggest investigators think so. 2. Who else knew? 19 courthouse employees testified. How many stayed quiet? For how long? Coming. The Judicial Council has a formal hearing scheduled Tuesday, March 3rd. Cannon's attorneys can present evidence. The House Judiciary Committee has announced hearings for Thursday, March 5th, expected to call DOJ witnesses. DOJ's Inspector General report, expected Friday, March 6th, will address whether criminal referral is warranted. Cannon herself is reportedly preparing a public statement for Monday, March 2nd. First time she'll speak directly since removal. Date to watch, Friday, March 6th. The Inspector General report will likely determine whether this stays an administrative matter or becomes a criminal prosecution. Should know more by then. The classified document angle is what makes this unpredictable. If materials were compromised, shared outside proper channels, this becomes a national security case. Different rules, different stakes, different outcomes. Right now, we're watching in real time. Subscribe. I'll cover every one of those dates. Tuesday's hearing. Thursday's congressional testimony. Friday's Inspector General report. When the documents drop, I break them down. Notifications on. This story's moving fast. Where we are right now. Judge Cannon formally removed from the bench. 14 boxes of classified materials seized from her chambers. 34 pending cases reassigned to other judges. Criminal referral under consideration by Inspector General. Supreme Court appeal pending. No timeline for response. FBI investigation ongoing. Scope unknown. Scheduled Monday, March 2nd. Cannon's first public statement expected. Tuesday, March 3rd. Judicial Council formal hearing. Thursday, March 5th. House Judiciary Oversight hearing. Friday, March 6th. Inspector General report release. Not public yet whether additional search warrants are planned. The FBI hasn't commented on scope of their investigation, whether other judges are being reviewed. The whistleblower complaint mentioned systemic concerns beyond Cannon. Whether she'll face arrest, legal experts say criminal charges are possible but not imminent. Clock's running. The administrative process moved faster than anyone expected. The question now is whether criminal process follows and how quickly. Cannon has resources. She has allies in Congress. She has media support from certain outlets. But she also has 340 pages of documented allegations, 19 witnesses under oath, and 14 boxes of evidence now in FBI custody. That's the situation. That's where we are. Judge Aileen Cannon, removed, fighting back, facing potential criminal exposure. Surface read, unprecedented judicial accountability. But this took over a year after the first complaint. Over a year of continued rulings, continued cases, continued access to classified materials. The system worked. Eventually. After it failed first. I'll be watching the Inspector General report Friday. That's the document that determines what comes next. Story's not over. Still developing. What happens this week, the hearing Tuesday, the congressional testimony Thursday, the IG report Friday, shapes whether this is remembered as justice served or political warfare. Maybe both. Subscribe for the full picture, not just headlines. When the documents drop, I'll break them down. Same way I did today, page by page, filing by filing. No spin, just what the record shows. Whether you think she's guilty or railroaded, you deserve to see the actual evidence. That's what I do here. Tuesday's hearing is 3 days away. I'll have coverage ready. Talk soon.